courtroom and then sit down. And the first thing they do is admit. Um, and they will do the opinions off the bat, then do admitting new Supreme Court lawyers, although they could do it in reverse order. But then the audio of oral argument will start as well. So you won't hear audio of the opinion release because the justices have decided not to do that for now for whatever reason. But you can hear the live audio of oral arguments. And so sometimes the justices read briefly from what the decision is. If there's a strongly worded or felt dissent, then there may be a dissent briefly read from the bench or described from the bench. And then the justices will either move to the next opinion if there are multiple opinions or move on to the business of the day. And that will happen in just about 10 minutes. So we will all find out together what decisions. Sweet darling, we don't know what they're deciding today. We're all going to find out together at 10 a.m. on the dot, and I'll talk you through it. So the way it works is if there are, thank you. My vibe is it's midnight in Japan and I set an alarm to wake up for you guys. So my brain will be slowly catching up. Last week when we did this, I was still in Japan and we had 3 opinions, all on different subjects. And so that was a nice midnight challenge. Perhaps we'll have the same thing today. But if you want to look through 2 things, if you want to see what types of cases we could be seeing this morning, cases that have already been argued, that have been fully briefed, had oral argument, and the Supreme Court has had a chance to fully consider and begin writing the decision. You can go look on SCOTUSblog.com and then click cases in October 2024 term. We're still in the middle of the term, so there's still cases yet to be argued, including later today after the court releases 1 or more opinions. But the cases that have been argued that we could be seeing the decisions from in 8 minutes are on that page, October term 2024. And you can see the cases listed from the October sitting, the November sitting, the December sitting, the January sitting. We're just now into the February sitting. And you can see which ones have been decided and which ones have not been decided. And you can make a guess for yourself as to what decision we might be getting today and tomorrow. Perhaps it's one that has been pending for a while, like the ghost guns case about regulating and having some of the same requirements of ghost gun manufacturers that are required for federally licensed firearm dealers. That one's been pending since the second day of the term. That was the second day of oral argument in October. That was Garland v. Vanderstrack. Now it's Bondi v. Vanderstack. That could be one of the decisions we get. That's now been pending for the longest without a decision. We have a decision from both cases that were argued on the first day of the term on October 7th. But you can see all of the others for yourself and take a guess before we actually find out all together in 7 minutes. So the second thing is you can read the decisions yourself. I'll read them for you, at least briefly off the top. I'll explain the majority, if there's any dissent, who's writing the decision, the holding, and then a little bit of the reasoning, which depending on the justice, sometimes is very crystal clear right off the bat. Sometimes it takes a little bit. And all of this happens right at 10 a.m. So the justices and the press office will physically release the opinions in the building. We'll get them online and you can get them and read them as well if you prefer to do that. But you're also here for me to do it for you. So you can be doing other things throughout your morning. But you can go to supremecourt.gov/opinions and then hit opinions of the court. And we're just going to hit refresh over and over again. Midnight in Japan is hitting me, but it's okay. We're going to do this together and I'm very awake. You can hit refresh over and over and over again until the opinion drops. So a couple of things to know once opinions start to come online. First, you'll know it's the final opinion when the number in the R column is filled. So this is kind of what it looks like. It'll be backwards to you guys, but this is what the chart looks like. And you see that R column all the way to the left next to the date. When there is a number in that R column, that means that's the final opinion of the day. I'll also tell you it's the final opinion of the day, or if we're expecting more. If it's empty, you know you're going to get at least one more opinion that day. This kind of matters more once we get toward the end and you're trying to discern, are we getting one of the more closely watched cases? But the opinions are released in order of reverse seniority of the justices. So the most junior justice who has an opinion that day releases them first. So for example, last week when we had 3 opinions, the first one was released by Justice Kavanaugh. Then it was Justice Kagan, followed by Justice Sotomayor. So they were released in reverse seniority, a Trump appointee, followed by both of President Obama's appointees. So sometimes, if you get a Thomas opinion and it's not the final opinion of the day, the next decision is either from Justice Thomas or perhaps from Chief Justice Roberts, who tends to have some of the more, pick your descriptor, but momentous or closely watched, important decisions. Arguably, they're all important decisions, but different pockets of nerds focus on different cases. But it also could mean a per curiam decision, which is a decision from the court speaking collectively as one voice. I missed your 5-minute buzzer, which is ringing inside the Supreme Court, or rang a minute ago. Now we have 4 minutes until decisions come down. Yes, it's about ghost guns, for the individual asking about that case that we're waiting on. One box today. Elena, our editor, is texting me. I forgot to check in with the live blog. So 1 box of opinions, likely a light day. So perhaps, one of the decisions they thought was ready for today was not quite ready and they're kicking it to tomorrow. Maybe we're getting one today, one tomorrow. We'll see. The magic and mystery and drama of an opinion day is we don't know until the court releases them at 10 a.m. But 1 box today means likely 1 or 2 decisions. That's great. Thanks for joining from Nebraska. Phones and computers are allowed in the Supreme Court press room, yes, but you can't stream. So you'll see me when I'm back in the States on opinion days. I'm sitting outside the Supreme Court usually. So that I could be with you guys, because I can't stream from inside the Supreme Court. You can't go live or have video inside the Supreme Court, but you can have a phone and computer. I think I'm not the only person in Japan on the Supreme Court website, but you never know. I actually know that I'm quite close to the Japanese Supreme Court, but I asked if I could go in earlier and they said I couldn't, so bummer. Oh, thanks, Cynthia. Welcome. Hi, Rob from Florida. Okay, this is your 2-minute buzzer, you Amtrak riders. I went to a different floor, so I didn't wake up my husband, who is sleeping, because that's normal at midnight. And on this floor, the elevator just randomly opened, which we're just going to ignore. It's not creepy. And we'll get opinions in 2 minutes. Charlie, we don't know what we're expecting today, but if you want to take a gander and a guess, you can go to SCOTUSblog's October 2024 term, and you can look at the cases that are still pending. You can also see the cases where we've gotten decisions. This is our 1-minute warning. Everybody cross your fingers for my internet in Japan. Last week it got a little wobbly right off the top, but we made it. Maybe it's a Japanese ghost. I don't know. All right, so 1 minute. You can also follow along on SCOTUSblog's live blog, where Amy will be breaking down the case and the decision as well. She's heading in. So physically, I'll tell you what it's like physically in the press room. All of the reporters physically who were there gather around the desk of the press office, and they wait literally until the second countdown of 10 a.m. and then run. They grab the paper and run. It's 10 a.m. So I'm going to start hitting refresh on the court's website. As always, if you guys get the decision before I do, let me know. I should catch up shortly thereafter if you're ahead of me, but internet is working well today, so we should find out at the same time. But anyway, you get a physical copy while I'm hitting refresh. You get a physical copy in the press room, and then you run back to your desk and you read it, and you either tweet it or however, Blue Sky or whatever, you get out the information. SCOTUSblog has the live blog, so they're, and they've been live blogging opinions for a long time. This is on TikTok. It's just the social media modern equivalent of what used to be the very modern equivalent of live blogging. Hitting refresh. Again, it's only a 1-box day, so it's likely to be only 1 or 2 opinions. I don't have the decision yet, but let me know if you guys do. Yes, Kev, they still do the running of the interns. So that's when, particularly later in the term, when we know, some of the big hot button ones are left, news agencies will have interns physically get a copy of the opinion and run it out. However, it's a little bit less critical these days because you can, as we're doing, get them online as well. It used to be that the Supreme Court didn't release them online until later. But now that they drop them live at 10, I'm just checking the live blog to see if they have anything. Thank you, Care Bear. I'm still hitting refresh. No decision yet. It's not on the live blog yet either. Has anyone else gotten it yet? Sometimes it takes a minute or two to upload. Clearly, we're on minute 2 now. 1 box means it's there's just 1 physical box of paper copies in the press office. So that just means it's going to be, we're getting glossip. It is not the final decision of the day. It's delivered by Justice Sotomayor. Justice Sotomayor delivers the opinion of the court, joined by the Chief, Kagan, Kavanaugh, and Jackson. Barrett joined part. She filed an opinion concurring and dissenting in part. Thomas filed a dissenting opinion, joined by Alito, Barrett in part. Gorsuch took no part in the decision of this case. The holding the court has jurisdiction to review the OCCA's judgment. Oklahoma precedent confirms that the OCCA normally rejects an attorney general's confession of error only after finding it unsupported by law and the record, by making the application of the PCPA contingent on its determination that the attorney general's confession of federal constitutional error was baseless. The prosecution violated its constitutional obligation to correct false testimony. Because the Attorney General's confession of error is supported by ample evidence, the court declines to remand this case for further evidentiary proceedings. When the court has jurisdiction, a new trial is appropriate remedy for a violation. Wow. Okay, so this is about a criminal death row case. So an Oklahoma jury convicted Richard Glossip of paying Justin Sneed to murder Barry Von Treese and sentenced him to death. At trial, Sneed admitted that he beat Von Treese to death, but testified that Glossip had offered him thousands of dollars to do it. Glossip confessed that he helped Sneed conceal his crime after the fact, but he denied involvement in the murder. Nearly 2 decades later, the state of Oklahoma disclosed 8 boxes of previously withheld documents from Glossop's trial. And these documents show that Snead suffered from bipolar disorder, which combined with his knowledge of his known drug use, could have caused impulsive outbursts of violence. They also established, the state agrees, that a jail psychiatrist prescribed Snead lithium to treat the condition, and that the prosecution allowed Snead to falsely testify at trial that he had never seen a psychiatrist. Faced with that evidence, Oklahoma's Attorney General confessed error. Before Oklahoma's Court of Criminal Appeals, the OCCA, the state conceded that the prosecution's failure to correct Snead's testimony violated NAPIU v. Illinois, an old Supreme Court case from the 50s, which held that prosecutors have a constitutional obligation to disclose false testimony. The Attorney General accordingly asked the court to grant Glossop a new trial. The Oklahoma Court of Appeals declined to grant that relief because it held the state's concession was not based in law or fact. But as Justice Sotomayor with the majority here holds, because the prosecution violated its obligation under the Supreme Court's precedent in NAPIU, they reversed the judgment below and remand the case for a new trial. That's one of the major cases that especially criminal lawyers were watching. So that is a win for Glossop and a new trial ordered in that case. This was, as Amy's reminding folks, and we just talked about off the top. Wait, let me make sure we don't have the second opinion of the day. Hang on. Because we know it's not the final one. And because Justice Sotomayor, the most senior justice appointed by Obama, wrote the decision, the next decision that we'll get is from either her again, although she had one last week and this week, or a more senior justice on the court, so Alito or Thomas or the chief. I'm just going to hit refresh until we get the next one. But for those who are just joining, we just got Glossop v. Oklahoma, the Supreme Court in a fractured decision with Justice Sotomayor writing the dissent, and it looks like Barrett joining both the majority and the dissent. I'll get to the details of that once we get the final opinion of the day. But granted Glossop a new trial. Here, Amy's pointing out what Barrett says in this case. This is the case where the Oklahoma Attorney General joined Glossop in arguing for a new trial and confessing error by the state because they didn't give him these 8 boxes of evidence showing that there was false testimony on the witness stand by this guy who testified against Glossop, who turns out was bipolar, but that wasn't disclosed to Glossop during his criminal trial, and was prescribed lithium that could have made him prone to violent outbursts at the time. Barrett, she concurred in part and concurred in the judgment, but then also joined part of the dissent, said that she would not order the Oklahoma Court of Criminal Appeals to set aside Glossop's conviction. Instead, she said the court should have corrected the state court's misstatement of NAPIU and sent the case back for further proceedings. Sotomayor is still reading from her summary decision, according to Amy. Thomas, in his dissent, says that the court stretches the law at every turn to rule in his favor. All right. See if we have the second opinion yet. We don't, because it sounds like Sotomayor is still reading from her majority. So for those who are just joining, the Supreme Court has ruled in Glossop's favor, vacated his conviction, and ordered a new trial in the Oklahoma v. Glossop case. He was convicted for murder after an individual testified at trial that he was paid thousands of dollars by Glossop to murder this individual. And Glossop admitted to helping this individual conceal the murder after the fact, but said he didn't have anything to do with the murder itself. 20 years later, the state confessed error by not giving Glossip evidence, key evidence that would have been, of course, critical in his own defense about the individual who made this confession against him, including that he suffered from bipolar disorder, had known drug use, and could have been causing or relating to impulsive outbursts of violence. Let me just check to make sure we haven't gotten the next decision yet. Amy's pointing out in the chat, Thomas's dissent at 44 pages is 15 pages longer than the majority decision in this case. It is a split decision. So it sounds like the justices are reaching the conclusion of this decision while they're on the bench. So I'm going to go back to hitting refresh, and then we can read a bit more about Glossip once we get the final opinion of the day. This was a one-box day, so I would expect we're likely only getting one more decision, but we'll see. Hi to all who are joining. We just got the first decision from the Supreme Court in Glossip v. Oklahoma, and we just got the second by the Chief. Lackey v. Stinney is the case out of Virginia. So this is the Chief, joined by Thomas, Alito, Kagan, Gorsuch, Kavanaugh, and Barrett. Jackson filed a dissenting opinion, joined by Sotomayor, so a 7-2 split. The holding is that the drivers here, the Virginia drivers, plaintiff drivers here, who gained only preliminary injunctive relief before this action became moot, do not qualify as prevailing parties eligible for attorney's fees under Section 1988B because no court conclusively resolved their claims by granting enduring judicial relief on the merits that materially altered the legal relationship between the parties. This is a case out of Virginia about attorney's fees. But hang on. Okay, so respondents, Virginia drivers whose licenses were suspended due to their failure to pay court fines or costs. This is actually a big deal in the DMV and a huge debate also about safety with drivers racking up some of these fees. But anyway, so a group of drivers whose licenses were suspended due to failure to pay court fines or costs. The drivers sued the commissioner of Virginia's DMV under Section 1983, which allows you to sue government officials in certain circumstances, arguing that the Virginia statute requiring suspension of their licenses was unconstitutional. The district court preliminarily enjoined the commissioner from enforcing the statute, but before the case reached final judgment, the Virginia General Assembly repealed the challenged law, rendering the action moot. The question presented is whether the drivers are prevailing parties who qualify for an award of attorney's fees under Section 1988B. Until recently, a Virginia statute directed the courts to suspend a license of any driver who failed to pay any fines, costs, forfeitures, restitution, or penalty, blah, blah. The suspension remained in force until the amount due was paid. In December 2018, the district court I'm skipping ahead. Virginia drivers whose licenses were suspended sued the commissioner. The drivers alleged the statute was facially violated the due process clause, blah, blah. Background of the case, blah, blah. Fourth Circuit, blah, 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 blah. We granted cert to determine whether the term prevailing party in 1988B encompasses the party who is awarded a preliminary injunction. If the case becomes moot before the court reaches final judgment. Since 1796, the chief writes, this court has maintained that the judiciary itself would not create a general rule independent of any statute allowing awards of attorney's fees in federal courts. The principle that the prevailing litigant is ordinarily not entitled to collect a reasonable attorney's fee from the loser became known as the American rule. Federal courts may depart from this rule only when there is express statutory authorization to do so. In 1976, Congress adopted the Civil Rights Attorneys Fees Awards Act. The law provides that in actions brought under certain civil rights statutes, including 1983, the court in its discretion may allow the prevailing party other than the United States a reasonable attorney's fee as part of the costs. The question is whether the drivers in this case qualify as prevailing parties within the meaning of 1988B. And the holding here is They don't. And that's because Virginia repealed the law, which basically mooted their case. And that is the final decision of the day. So 2 decisions today, Glossop v. Oklahoma, a major one. A lot of folks were watching this one. A win for Glossop, who got his conviction vacated and a new trial ordered. That was delivered by Justice Sonia Sotomayor, who was joined by the chief. Hang on, I want to make sure I get the split right in Glossop. It was a bit fractured. Sotomayor was joined by the chief, Kagan, Kavanaugh, and Jackson. And then Barrett concurred in part and dissented in part, but concurs in the judgment. And then Thomas filed a dissenting opinion, joined by Alito, also joined by Barrett in part. And Gorsuch didn't take part in consideration of that case, but Glossop got a new trial. This was a case where Oklahoma's attorney general joined the criminal defendant in saying he should get a new trial here. We should toss out what happened because it was frankly crazy. And then the other decision was a case out of Virginia about drivers who challenged a now defunct law in Virginia that required individuals to lose their licenses if they didn't pay court fees and fines that racked up. The Virginia legislature repealed the law, which basically rendered the case moot, but the drivers still wanted to recoup their attorney's fees for filing the lawsuit in the first place by saying that they were a prevailing party. But the chief, writing with Thomas, Alito, Kagan, Gorsuch, Kavanaugh, and Barrett in the majority, held that they are not the prevailing party. Jackson dissented, joined by Sotomayor. As Amy points out in the chat, they write, and this is the Virginia drivers case, attorney's fees case, that there is no persuasive reason to believe that Congress meant to preclude fee awards for every plaintiff who secures preliminary injunctive relief, but not a final judgment, no matter the context. So that's kind of parsing here. Yep, and she's saying the court has now moved to bar admissions, and then they're going to hear oral argument in 2 cases today, which you can shortly hear if you want to go listen on SCOTUSblog's website. The link is at the top. You are perfectly welcome to go listen to oral arguments live. Amy's covering both of the cases today live in the courtroom. I'm still in Japan, so I'm not. I'm going to go back to bed, but we can do a summary later if you guys are interested. Amy will also have a summary on SCOTUSblog's website. And that ought to do it, folks. And we will have another opinion day tomorrow. So yours truly will be setting a midnight alarm once again to join you and talk about whatever the court brings us tomorrow. Yes, a lot of folks will be happy for Richard Glossop in this case. Although query exactly what's going to happen implementing the court's order for a new trial. But suffice it to say, it's a win. You lost sound for a minute. Oh, hopefully you guys can hear me. You guys are welcome. Okay, Southern Strategists, this is the last quick recap. We got 2 decisions today. We got Glossop v. Oklahoma, where the Supreme Court sided with the Oklahoma AG and Richard Glossop, who were both arguing that basically he got screwed, and that his conviction for murder should be vacated and a new trial ordered. That was Justice Sonia Sotomayor, who was joined by the chief. My midnight brain isn't going to remember it exactly, the split. Joined by the chief, Kagan, Kavanaugh, and Jackson, and Barrett, who concurred in part. And then Thomas dissented, also joined by Barrett in part. And Alito joined, and Gorsuch didn't take consideration. Then in a case about Virginia drivers who were challenging a law that took their licenses away from them because they weren't paying their court fines, They filed the lawsuit, then the Virginia legislature repealed the law because they were arguing the law was unconstitutional. And they were saying, hey, we should still get attorney's fees as the prevailing party. And the Supreme Court said, no, that's not really how it works. Those are the two decisions. All right, folks. I am going to go get sleep. We'll do this once more, and then hopefully I will be back on the Supreme Court's time zone for the next opinion day, unless they decide we're going to have one more this week. But we will have opinions tomorrow, and then hopefully that should be it. They would tell us by now, I think, if we were getting anything else. That doesn't mean we won't get any kind of emergency order later this week, but not an opinion from a merits case. Okay. It's Wednesday for me, but happy Tuesday for all of you. Have a great day, everyone, and I'll see you tomorrow morning. You're not importing your SCOTUS news from Japan. I'm usually always giving it to you from the United States. I'm just traveling, so don't worry. Okay, bye, guys.